Erstmal herzlich willkommen zu dem Vortrag Täterarbeit, Intervention plus Prävention gleich Pflichtaufgabe. Ich habe mir das so ein bisschen als Gleichung gedacht und will Ihnen kurz zeigen, was ich gedenke, mit Ihnen zu besprechen. Ich will zunächst einen Blick auf die Entwicklung der Täterarbeit in Deutschland werfen, die Verankerung der Täterarbeit in Deutschland dann thematisieren, ausgehend von Europa und die Umsetzung der europäischen Vorgaben in Deutschland anhand der Istanbul-Konvention prüfen und auch auf die aktuellen Berichte eingehen und dann einen Ausblick geben auf das, was aus meiner Sicht zu tun ist. Wenn ich für das Dolmetschen zu schnell rede, geben Sie mir bitte ein Zeichen. Vielen Dank. Wie ich Ihnen schon in der Ankündigung meines Vortrags geschrieben habe, ausgehend von der Istanbul-Konvention haben wir geltendes Recht in Deutschland seit dem 1. Februar 2018. Die Täterarbeit, die in Artikel 16 geregelt ist, ist aus meiner Sicht jedenfalls zugleich unverzichtbarer Teil der Intervention bei einer nachhaltigen Bekämpfung von genderspezifischer und häuslicher Gewalt. Und die wird auch verortet in der Istanbul-Konvention
Since 2018, the Istanbul Convention has been applicable federal law in Germany. Its implementation is a mandatory task for all levels, the federal, the state, and the local level. Work with perpetrators is at the same time a part of intervention in the sustainable fight against gender-based and domestic violence, and at the same time part of its prevention. In terms of funding, however, this fact has not been accepted. This is what has been done so far. 2007-2008, an action plan by the German federal government was developed with the relevant standards. The federal government published standards and has been promoting individual projects. In 2013, a law was passed to strengthen the responsibility of offenders. It has been in force since 2013. In 2017-18, a law was passed on the ratification of the Istanbul Convention. So Article 16 concerning the work with perpetrators has come into force. In 2020-2021, the federal government submitted a report on the implementation of the Istanbul Convention in Germany. And a shadow report of the Istanbul Convention Alliance was also published. In October 2022, the opinion of the Council of Ministers and of the Council of Europe was published on the implementation report on Germany. And so this took place in October of this year, and I will go into details of this later on. So, first of all, we have to focus on the development of the activities with offenders. In the period between 2000 and 2007, supporting associations were founded. For example, BAG, TAHG, the Association for Work with Perpetrators in Domestic Violence. Working group to develop standards at a national level was set up in 2005, and in 2007 a symposium took place and to develop standards. In the meantime, the work with perpetrators was subject to an evaluation by the University of Osnabrück, and other meetings took place. As I said, in 2007, standards were developed and they were adopted by in Germany, and the association was founded, as I said before, with stakeholders from the society and from the government. Here you see how the work with the perpetrators is anchored in laws and regulated by law. In particular, you see that in 2012, a law was passed to strengthen the responsibility of offenders, which came into force on March 1st, 2013. And the idea was to make victim protection more effective, especially in cases of domestic violence. Specific offender programs, qualified offender programs were implemented. And so from a judicial prosecutorial viewpoint, instructions were published on how to deal with accused persons. Then, as far as the regulation in Europe is concerned, we have Article 16 of the Istanbul Convention. Here you see the articles, in writing. Paragraph 1 in particular defines the work with offenders, and you see that the parties involved shall take such legislative or other measures as may be necessary to establish or support programs aimed at teaching perpetrators of domestic violence to adopt non-violent behaviors in interpersonal relationships. The idea is to prevent further violence and to change patterns of behavior characterized by violence. The security and safety of the victims is one of the priorities of this program. As a matter of fact, these programs are developed and implemented in close cooperation with support services. So the principle is to combine intervention and prevention in working with offenders. So the final goal is to avoid a spiral of violence by reacting as soon as an episode is reported, and then so intervention is implemented, and at the same time prevention is also put in place for the future. That's why the principle is that intervention and prevention should occur at the same time in order to, as I said, avoid a spiral of violence and the building of tension, because we have specific phases that take place. So a violent phase, then a quieter phase, a tension building phase, and so it is necessary to intervene proactively in order to protect the relationships in the future, including children. This is extremely important. And so that's why we have to intervene in the acute phase, in the so-called honeymoon phase, so that interventions can be put in place and so that the program can be implemented through a specific offer. Because if you act in the honeymoon phase, you can still approach the offender and so in this respect, he or she is also ready to accept the offer provided by the program. And that's why intervention has to be coupled with prevention, both for the existing coupled relationships, but also for the future relationships that involve children, so that the behavior of the offender can be changed. And that's why we should work proactively. And this is, in my opinion, indispensable. In Germany, we have a report that was published in 2020, and there we made reference to the work being carried out by the task force Gravio. This is an example that takes place in Hamburg and in the region of Thüringen. In Lower Saxony, we also have other projects, for example, association set up in 2015 with proper funding so that the programs can be put in place. And so thanks to all these activities and these reports, we managed to obtain funding from projects through the federal government. For this reason, I think it is necessary to guarantee funding to these projects. Gravio has, the task force that I mentioned earlier, published an evaluation report on the Istanbul Convention. Gravio strongly appeals to the German authorities to increase their efforts to ensure the establishment of specialized programs for the perpetrators of domestic violence throughout the country through sustainable public funding and on the basis of the standards approved by the federal ministries for family affairs, women and youth. It is important to implement these programs, to introduce them in prisons where they do not yet exist. And as you can see, under letter A, it has to be ensured that the work with the perpetrators takes place in local structures and in close cooperation with all stakeholders so that it can be really used and so that you can reach offenders, also in prisons. It was also asked to raise awareness and disseminate knowledge about offender work among relevant law enforcement agencies and judges who are legally empowered to order offenders to participate in such preventive intervention and treatment programs. As far as I know, this last point still has to be improved. In the meantime, we managed to reverse the trend thanks to these programs, and I think it is extremely important. Likewise important is to ensure that the impact of all programs be independently monitored according to uniform methodological rules, and that independent scientific studies are carried out. So in our programs, it is absolutely necessary to obtain the right necessary funds to allow this type of evaluation. This is the last area I'd like to deal with. So what still remains to be done in terms of laws and practical measures? What we still miss is a comprehensive, proactive approach. So far, we have 3 model projects, but we have to be much more proactive. Having only 3 projects is not enough, so we need further funding, and we need also changes in the legislation. Grevio is urging Germany to ensure standard-based programs for perpetrators of domestic violence across the country. So we really need to get the right attention and the right resources in order to be successful. We have the problem, for example, that perpetrators may come from 30 kilometers away, and also for financial reasons, we were not able to reach them. So I do apologize for the layout of this slide, but as you can see, this is the issue of the treatment of personal data, which is a very delicate point in relationship with work with perpetrators. In the investigation phase, we have statutory provisions, as you can read in the slide. The purpose basically is to examine the suitability of an offender program within the framework of the existing regulations. And so the public prosecutor's office, the investigators of the public prosecutor's office at the police station and the court are all involved and must consider the treatment of personal data. Afterwards, in the hazard prevention phase and in the implementation of the training, specific regulations have to be complied with. If it's only a question of hazard prevention, we have a more difficult situation because we have different laws and regulations regulating the disclosure of personal data. All police officers are involved and they have to comply with their relevant laws and regulations in checking and disclosing personal data to third parties. Finally, we have those who call personally and who identify themselves personally. In this case, these people must give consent to the processing of their personal data too. Das ist aber etwas, was mit einer Einwilligungserklärung des Täters erledigt werden kann. Was nach den gesetzlichen Vorschriften im Ermittlungsverfahren und auch im Bereich der Gefahrenabwehr immer erforderlich ist. What is always required, both in the investigation phase and in hazard prevention or in case of self-identification, you always need the consent of the persons involved, both the injured, the victim, the injured person, the victim, witnesses. Well, they all have to provide their consent to the disclosure and processing of the personal data. Die Opfer sind aber an diesem Verfahren nachher zum Beispiel nicht beteiligt. Deswegen muss man da ausdrücklich. That's why during the investigation phase, although activities tend to be focused on the possible offenders, victims are too involved and they must provide their authorization. That's why in some regions we are pursuing these discussions in order to implement the right standards. In terms of law changes, I have included 3 areas. On the one hand, we should complement the law by adding some specifications concerning the chain of intervention in cases of domestic violence. So we have a paragraph 1 that should be added and which we can read: in order to protect persons affected by domestic violence according to Article 3b of the Istanbul Convention, the court may also order participation in a standardized social training course according to Article 16 of the Istanbul Convention for a maximum period of 1 year upon application of the applicant according to paragraph 1 of the law with the consent of the respondents. Wo man im gesetzlichen Bereich, im Gewaltschutzgesetz, das auch möglicherweise auf freiwilliger Basis, nämlich auf Initiative des Opfers, implementieren kann. Ob das im Einzelnen funktionieren kann, ist noch nicht. It is still not completely clarified, and it has not been completely regulated up to which extent this can actually be passed and added to the existing law. There is a project in Austria, in the region of Steiermark, and there, in addition to the ban concerning approaching the victim, the violence prevention counseling, according to paragraph 25, is mandatory. So the idea is to stop violence and to put in place a crisis intervention with 3-4 meetings within 6 weeks. And this is a very nice example, in my opinion. And I think we should check whether it can also be applicable in Germany as well, in order to possibly include this in our country as well. So what is yet to be done? In my opinion, what is absolutely mandatory is the third point of my presentation, that is funding. And the German government should provide funding both at the level of the federation and at the level of the regions. The ministries involved should not only be those of family and youth, as it is the case for Lower Saxony, but also the ministries of internal affairs and the ministries for justice, because these are the areas in which the work with perpetrators applies, and for this reason they are important interfaces, and measures should be regulated by law through the support of these ministries as well. And the funding of the staff involved should be in line with the BAG standards. And this is, in my opinion, something that should be guaranteed and implemented according to the regulations passed by the German government. The idea as the ultimate goal is that if we want to get started, we have to stop talking and start acting in order to anchor the work with perpetrators in the law, in the national law. Here you see a summary of what I've said. All actors in the regional network at the state level and at the federal level must now finally implement the establishment of the proactive approach of offender work at a national level in reasonably accessible proximity. Thank you very much for your attention, and I'm ready to answer your questions. Thank you again.